All right, good evening, everybody. This is the Thursday, October 11th, regular meeting of the Santa Monica Rent Control Board, and we are hereby called to order. Love my gavel. Will the secretary call the roll?
Commissioner Phyllis.
Here.
Commissioner Drum.
Here.
Commissioner Trosas.
Here.
Commissioner Foster.
Here.
And Commissioner Flores absent.
Let's stand for the salute to our flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right. Let's take a moment to review the minutes of our last meeting. I'll entertain a motion to accept the minutes.
So moved.
Second. Oh,
All right.
you go ahead.
Don't fight over it all at once, kids. All right. All those in favor of approving the minutes say aye.
Aye.
All right. Minutes are approved. Okay. Mike's not working. No. Do you want to move to a different seat? We're going to pause for a technical issue for a moment. There might be a...
Yeah, you might have to move to
Yeah, so Tracy, I was just going to say, Tracy, why don't you go ahead and give the executive director's report of special agenda items or announcements.
Oh, here's somebody for some city TV to help as well. Really quick.
Wow.
Look at that service.
He heard the call.
All right. I just have one announcement this evening, and that's that the board's next seminar will be next Tuesday morning from 9:30 to noon, and this is a seminar on rental property maintenance. We offer it with the city's code enforcement division, and we provide information about different types of maintenance and repairs that are required of controlled residential units, and how and where to file a complaint and cover additional issues. There's also time for questions and answers. So anybody who's interested in attending is welcome, and they should contact the rent control office either by phone at 310-458-8751 or by email. And I just want to mention that the email list that we've been working on putting together has been very effective. Just yesterday, we only had about 15 people signed up for this seminar, and then Mr. Costello sent out an email blast, and today we're up to 50 plus people. So
Wow.
Music to my ears.
Yeah, so that's
Wonderful
great.
news.
So thank you to Mr. Costello and Mr. Gwynn who have been working on that.
Excellent. All right. Moving on to public comments. This is the time we set aside to hear from the public. Please limit your comments to things that are under our powers to do something about, but not on our agenda tonight. We have one request to speak. That's Elaine Golden-Geeler. You can write a late chit and we can vote to accept it.
Is it just a general comment or about a specific item?
Oh, it's something I would like to bring up that I would ask the Santa Monica Rent Control.
So this conversation, this question you have should be taken up right over here on the side with Lonnie while we proceed. Thank you. Go ahead, speaker.
Okay. The Santa Monica Mirror newspaper asked its readers to submit questions for rent control board candidates. Here are my 4 questions. Question number 1, how many rental units were there in 1979 when rent control began, and how many are there now? This is kind of a cheat sheet for rent board candidates who don't know the answer. In 1979, there were approximately 39,000 rental units. In 2018, there are approximately 26,000 rental units. Congratulations. Thanks to your punitive regulations, about a third of Santa Monica rental units have been lost. And now you want to blame owners for the housing shortages your policies have created. Number 2, please describe your experience with owning and managing income property in Santa Monica or elsewhere. This is for the candidates, not the current board members. I know the answer, and so should you. Question number 3, if you are a Santa Monica tenant and on the rent board, is it fair for you to vote on rent increase amounts? For your information, the one housing provider who was on the rent board was forced to leave the room when rent increases were being voted on. So all's fair. Maybe you guys should also have to leave. Number 4, tell the truth. Have any of you on the rent board ever violated the Brown Act? If your answer is no, please offer to take a lie detector test. Thank you.
I'm inclined to accept the late chit since we have sort of a light amount of public comment tonight. Any objections to accepting the late chit? Commissioner Trosis?
Yep. No objection.
Okay. All right, Mr. Senzi, you have 3 minutes when you start.
Thank you very much for giving me the opportunity to speak. I unfortunately am not under rent control. I live behind a house which is occupied by the owner with 2 units in the back. And I understand the rules are, under rent control, it has to be 3 or more units to come under rent control. But I just want to give you a brief story what happened to me so you can think about it in the future and for possible future measures. In 2004, my rent was increased 62%. You heard that number right, that's 62. The new owner bought the property from the previous owner who raised our rent to market value at that time. I was also straddled with a big dog at that time, and believe me, I tried to find affordable property to move, and I could not. This was an obvious attempt to force me off the property. I had done nothing wrong. I was a good paying tenant. My former landlords had no grievances against me at all. And I went to rent control. I went to lawyers. And not only that, between apartment A and apartment B, she discriminated against me and only raised my rent 62%, which to my mind is discrimination. And it's a very, very lonely feeling when no one will help you and you know you're being screwed. So I'm sure there are a lot of people out there like me that live behind a house and then maybe have only 2 units that don't come under rent control, and you get stuck with a lemon like I did. It could really change your life. So I implore you to try, maybe during the next election, push a measure where really all people that live in an apartment, even though it's maybe only 2 units, come under rent control, because it could really change your life. And it's a very tyrannical situation, because I'm pretty sure this individual right now is running an illegal business on illegal, and renovated the garage illegally and has at least 5 full-time workers going there. So it's a very tyrannical situation, because if you complain anything at all, your rent could be jacked and be forced off the property. So that's my bid. Thank you very much for your time.
I have a quick question. How long have you lived in the unit?
38 years.
I just wanted to know. So there was about a year and a half ago, we created what's called an info sheet for new tenancies, but it was also directed that the agency mail them to all existing tenancies. Do you recall receiving this front and back single sheet from the rent board?
No, I do not.
Yeah. Okay. Thank you very much. Commissioner Phillips has a question.
Just to clarify, do you know if your unit was, did your landlord ever tell you that your unit was under rent control prior to moving in?
No, that was the original landlord. No, when I first moved into the unit in 1981, I was just out of the service. I was out of the Navy. I was 24 years old. I didn't know anything about rent control or anything like that.
So the reason why I say this, and I'll keep it brief, is because obviously we have our rent control law in Santa Monica is different than the rent control law in LA. So duplexes and triplexes aren't automatically exempt from rent control. They're only exempt if the owner occupies the property and obtains an exemption. It sounds like they did in your case.
They did, and the new owner did, because I went to rent control. They applied for it in September of 2013. So as I stated, the owner does live in the front house, and there are 2 units in the back. But and that's my point, is that I'm sure there's a lot of people like me that, you have a good landlord, they maybe will raise you more than rent control allows, 5% or 8% even, which would be considered a lot. But to be raised 62% in an obvious attempt to force me off the property for no reason at all is wrong. And that's why maybe you might consider changing that law, that even if it's 2 units in the back of a house and it's owner occupied, you can be under rent control.
Thank you for your comments. Staff, can you clarify for the public who might be listening under what circumstances that would or could not be changed?
Okay.
We know. But.
Because the Santa Monica rent control law was adopted as an amendment to the city charter, it can only be changed by the voters of Santa Monica. And when it was adopted in 1978, it included an exemption for properties of 3 or 4 units that are owner occupied. So in order to change that, we would have to go back to the voters, and the voters would have to approve such a change. But it is something that over the years, different people have expressed the sentiment that you're expressing, and it is something that the board could reconsider putting before the voters. So, but it would require that type of change.
Right,
Thank
I know.
you.
We need to get a vote.
Thank you
need
for your
to change
comments
that.
tonight. Thank you very much.
very much.
All right. Moving on to item 10, jurisdictional items. We have 2 owner occupancy exemptions, speaking of. And can we have a staff report on item A1?
Good
Yes,
evening,
there is.
Commissioners. This is regarding the property at 1821 17th Street. The applicant is Mr. Marco Ramirez. Mr. Ramirez bought this 2-unit property back in December of 2014 and states that he's lived on it since May of 2017. He applied for its exemption as an owner-occupied property with 3 or fewer units. One of the tenants alerted staff to a 4th unit on the property, apparently an unpermitted conversion of a garage. And a 4th unit would make the property ineligible for the exemption based on the language of the charter. At the time the rent control law was enacted, there were 3 units on the property. Mr. Ramirez bought this property back in 1999. A couple years later, he repaired a dilapidated garage, added a bathroom, changed the wooden garage door to fiberglass, and extended plumbing to an additional sink and toilet, and created a kitchenette area. At the hearing, he initially testified this area was used as office space for himself and his son, or occasionally rented as office space to other individuals. Mr. Roth, a tenant since 2008, testified that when he moved in, Mr. Ramirez had told him that he actually lived in the rear unit, and to him it appeared that he did. Ms. Sokolovsky, another current tenant, also testified that she met Mr. Ramirez in the rear unit to sign her lease, and while there saw a bed in the rear unit. Mr. Roth also presented a letter from a prior tenant, Mr. Pala, who had lived on the property from 2008 to 2014. And in the letter, Mr. Pala said that his mother-in-law had rented the rear unit to live in when she moved onto the property temporarily after his wife, her daughter, had a baby. Mr. Pala then confirmed the contents of his letter by testimony over the telephone. He said that he moved in a bed, vanity, and dresser drawers for his mother-in-law for the duration of her stay in the unit. Mr. Ramirez, who had earlier testified that he had never rented the unit for someone to live in, didn't deny Mr. Pala's statements. He explained that he had not asked for money but took what was given as a friendly gesture. Mr. Pala, however, stated that Mr. Ramirez only agreed to the arrangement after a lengthy negotiation. Mr. Ramirez admitted that he had installed a security lock between the two rooms in the converted garage so that Mr. Pala's mother-in-law could have her privacy when the other room was being used by him. He insisted that he did not know they had furnished the room or that it was being used for living. He thought the mother-in-law would only stay there during the day. Given the inconsistency in Mr. Ramirez's testimony, his failure to admit having rented the rear unit to Mr. Pala's mother-in-law, the hearing officer found Mr. Ramirez's testimony to lack credibility. And she concluded that Mr. Ramirez had rented the front room of the rear unit, which made the converted garage into a fourth rental unit on the property, and disqualified the property from an exemption. The hearing officer also found that notwithstanding the question of how many units there are on the property, Mr. Ramirez had failed to show that he intended to reside in the property as his principal residence in good faith. Mr. Ramirez owns a home in the Windsor Hills View Park neighborhood of Los Angeles above Slauson. In response to questions on the exemption application about whether he owned any other residential property, he had answered no. The hearing officer asked about this other property, and Mr. Ramirez said that he used to live there, but he's currently renovating it. He testified that he doesn't know what he will do with the property after he finishes renovation. When asked if he moved to the Santa Monica apartment because of the renovations, he said actually he did it because he wanted to live closer to work. But Mr. Ramirez's office is on Slauson, very close to his home. And Mr. Ramirez explained that about 60% of the time he works in the field, which is usually in the Palisades and in Santa Monica. The record also showed that the board had granted Mr. Ramirez an exemption of the Santa Monica property back in 2000, shortly after he bought it, and before he had repaired and converted the garage or rented it to Mr. Pala's mother-in-law. When he bought the property in Windsor Hills in 2005, he moved into that home, but never told the board that he had left the Santa Monica property, which lapses the exemption by operation of law, and which he had been advised to do when the board granted him the exemption. Staff only found out about the move several years later when alerted to it, and after research of water records showed that Mr. Ramirez had moved. At the hearing, Mr. Ramirez also changed his earlier testimony and closed out by saying that he will sell the Windsor Hills home after he completes its renovation. Given Mr. Ramirez's failure to disclose the Windsor Hills home on his application, the inconsistencies in his testimony, his prior failure to disclose his move to Windsor Hills and the lapse of the earlier exemption, and the fact that he purportedly moved to Santa Monica to be closer to work despite the significant amount of time that he spends in the Slauson office near his Windsor Hills home, the hearing officer reasonably concluded that Mr. Ramirez had failed to prove by a preponderance of evidence that he intended to reside in the Santa Monica property in good faith as his principal residence. For both of these reasons, staff and the hearing officer recommended that the board deny Mr. Ramirez's application and adopt the hearing officer's recommended findings of fact and conclusions of law.
Thank you very much for that report. We do have one request to speak. Mr. Marco Ramirez, you have 5 minutes.
Good evening. My name is Marco Ramirez, the owner of 1821 17th Street, Units A, B, and C. So I just don't understand this, there was some, the hearing officer saying that I was going to move back to my house. It's going to be rented. And so that wasn't true. I do agree that I did a favor for one of my previous tenants. They were having a baby, so I wasn't really, after him insisting, I kind of just gave in that I was doing a favor for him. I never agreed upon a price or an agreement of any type or contract. He simply just gave me a gift, which I thought was just a nice gesture for him and helping him out because he was kind of backed up against the wall. 80% of my business is in Santa Monica. I have a home office on Slauson at a different property, but I just go there and do paperwork, drop off paperwork, but the majority of my work is in Santa Monica, so with traffic being the way it is nowadays, they save a good hour and a half, traveling from here to Slauson. So, the majority of my work is here. I'm going to stay here as long as I'm afforded the exemption here. But I don't know. What are we calling this fourth unit? Supposedly, it's not habitable. No one's ever lived there. I have rented it to a photographer. He's put his photography equipment in there, and he's worked from there. But that was it. I clearly stated that no one can sleep here. It's just day use. I did offer it to my tenants at one point, Roth, if they needed extra space, and they couldn't use the space. So I thought I'd keep it within the property and the tenants on the property, and they didn't want it. And then another neighbor expressed to me that, it's just make sure no one's going to be living here because, we're on the property here, and I respected that. And so that's what I did. The only time anybody's ever stayed there is the 6-month period where my tenant had a baby. So I'm just a little bit confused as to what we're calling this. 4 units, 3 units. I thought I met all the requirements. I mean, these are, to me, they seem as assumptions or presumptions that I'm going to be moving back to my house, but that's not the case. So what do we go from here? What do we do? Because I met all the requirements. Does anybody have anything to say?
We will wait for you to conclude your comments and
Okay.
take your seat, and then we'll deliberate. So we do not, in just a moment. So when you're finished with when you indicate that you're finished with your comments, then we will either ask you questions or not, and then we will proceed with our discussion.
Okay, that's pretty
Are you,
much it.
okay, so you've concluded your comments. Commissioner Trosas has a question for you.
Okay, thank you for being here. Is your house near your Slauson office currently under any sort of rental agreement? Are you renting it out to anyone?
No, I'm under.
Who
that
resides
process.
there?
Right now, it's vacant. I'm finishing up some final details on that, and then it's on the market now to be rented. Yeah, it is listed. It's been listed for several months now.
Was that information
Almost
given to the
6
hearing officer?
No, just thought she would take my word for it.
Because we're talking about whether in good faith this is your principal place of residence, not whether it's 3 or 4 units. Secondarily, did you know that it's illegal to collect rent on unpermitted dwelling units in California?
No, I just thought the place was grandfathered in. I went through major renovations to the property, got all my occupancy, everything's been passed. I got, so,
And why didn't you notify the board last time when your owner occupancy exemption lapsed and you moved to your house on Charlene?
I just figured it would just lapse, just like anything. I didn't know I had to notify them. I mean, they could clearly tell with the new tenants moving in that I wasn't there. You guys collect registration fees from me every year, so I just thought once you vacate, it goes back under rent control.
Okay, thanks.
So are there any more questions for this speaker, or are we moving into discussion? All right, we're moving into discussion. We have Commissioner Duran is next. Yeah, take a seat, thanks.
Okay, thank you very much. So, as I reviewed this, the issue that I keep hitting my head on is whether or not there is a 4th unit. And one of the things that caught my eye was that there is no shower there or bath. There's a toilet and there's a sink and I guess a hot plate or something along those lines. And what I run into is paragraph 44 RCAA 1801H, which defines the rental unit, and maybe my fellow commissioners can shed some light on this for me if I'm incorrect on this, but it's one of the things that it asks for is that, it says, any building or structure a part thereof or land appurtenant thereto or any other rental property rented or offered for rent for living or dwelling house units together with all housing services connected with use or occupancy of such property. And the issue I have is with all housing services connected. I mean, to me, based on the description, it doesn't have a shower, it doesn't have a bath, so I don't know how someone could actually live there. So that being said, I may not.
We're either gonna. Are you questioning the finding of facts on the? I'm curious. Are you questioning the staff's finding of fact?
Well, I'm reviewing what I read, and at this point, I'm just making my comments on what my issues were. So, no, not per se, but I'll get to that. And so, that's one of the issues that I have. To me, it sounds like this isn't suitable for a dwelling because there's no shower or bath there. And for that reason, it not being a fourth unit, I may not like some of the past behaviors. I don't think at this point that there's enough facts for me to agree with the hearing officer's recommendation in denying it. So I'm on the fence, but I'm kind of leaning towards granting at this point.
Commissioner Phyllis.
So it sounds like we have two questions before us. One is, does this type of building, does 1821 17th Street qualify for owner occupancy exemption at all because there's this bootleg unit? And then the other question is, has Mr. Ramirez met his burden of proof in terms of demonstrating that this is his principal place of residence? Can staff please clarify what the burden is? Like what quantum of evidence do we have to?
So he has to meet his burden by a preponderance of the evidence that he intends, not only that he resides there and has resided there for 4 months as his principal residence, but that he intends to reside there in good faith.
Okay. So that means it's more likely than not that he intends to reside there, correct?
That is correct.
Okay. So even assuming, I don't think we need to reach this question of is this property eligible for an exemption or not? You know, does the bootleg unit count? Is it habitable or not? Because I don't think that Mr. Ramirez has demonstrated by a preponderance of the evidence that he is intended to live here as his permanent domicile and that he's lived there for 4 months prior to the application. I mean, among other things, I think there's a lot of very, very specific evidentiary findings that shows that, among other things, Mr. Ramirez provided untrue answers with regard to his history of property ownership on Charlene Ave, that he did not disclose things, and that the other witnesses who had provided testimony with regard to the evidence with regard to domicile were credible. And when I look at things on balance, do I say, okay, is it more likely or not that this was Mr. Ramirez's principal place of residence? At this point, I can't get there. I'm not there. So, and that's without even getting to the 4-unit issue, which I think could also be dispositive. But if we can get there on the domicile issue, then I don't think we need to reach this 4-unit issue.
Commissioner Trosis, I'm going to yield to you, and I'll finish up.
Okay. Clearly, my thoughts on this were given away by my questions. I think that there are two issues. I agree with Commissioner Phyllis. We have one, as presented here, whether or not there was a 4th rental unit on the property, which would even qualify for something for an owner occupancy exemption. There are clearly no permits pulled Clearly, we have an unpermitted, maybe fourth dwelling unit. I think that this owner should be seriously concerned that anyone he charged rent to live in that fourth bootleg unit could come back and litigate for damages and for all of the back rent that he was not allowed to charge if, in fact, he did charge rent. So that's a concern. But irrespective of that, because I'm not here to give legal advice, I think we have the issue of whether or not he occupies the property as the principal place of residence in good faith. I think his credibility is in serious question. I think that, ignorance of the law is no excuse. We all know that. The fact that he said, I thought it would just, my owner occupancy exemption would just lapse. I didn't need to tell anyone. I mean, is that a landlord operating in good faith? I'm concerned about that. I'm concerned about the testimony that was given that was not matching. There were some potential, I don't want to say the word lies, but inconsistencies in the testimony. I do not feel that more likely than not he intends to reside there. And for that reason and that reason only, I am inclined to grant the hearing officer's decision.
Thank you for your comments. I'm in agreement with Commissioners Phyllis and Terosis, and there's a great responsibility that comes from buying and owning property that houses human lives, and it's up to those of us who do to understand the laws and the rules that apply. And someday, if that threshold is met, he's free to file again after a certain period. I'm ready to entertain a motion to take a vote.
Move to deny the exemption and accept the findings of facts and conclusions of law as stated in the staff report.
I would just amend that to say that I do not agree that there's a fourth rental unit on the property. So I would just say that I'm in agreement with the findings of facts as they pertain to the good faith return as the principal place of residence.
So friendly amendment without reaching the issue of the fourth unit on the property. We adopt the remainder of the findings and facts and conclusions of law with regard to whether the applicant resided in good faith as the good faith domicile.
Come on, you can do it. Counsel, is that satisfactory to deny based on one, if not both, and does that need to be specified by the body?
I understood what you meant to say, and
Okay.
I understand that you are choosing to deny the application based on the applicant's failure to meet his burden of showing that he intends to reside in the property in good faith.
And it has the same effect.
Yes.
All right, thank you. Clerk, please call the roll.
Did we second?
Oh,
I'll second.
I thought the friendly was, okay.
Commissioner Phyllis.
Yes.
Commissioner Trosis.
Yes.
Commissioner Drawn.
No.
Commissioner Foster.
Yes.
Motion carries.
All right, moving on to item 10A2, 225 Georgina Avenue, applicant T. Botten for an owner occupancy exemption. I myself found this report to be very straightforward and clear unless anyone else, we do not have a speaker, so unless any other commissioners want to discuss.
I agree. I would move it on the staff report and proceed to item 12A if there's consensus on the board.
Second.
Okay, we have a first and a second on granting the owner occupancy exemption. Commissioner Duran, do you have a comment?
No, I was going to second.
All right. So we're going to vote to accept the owner occupancy exemption at 225 Georgina. Please call the roll.
Commissioner Trosis.
Yes.
Commissioner Drawn.
Yes.
Commissioner Phyllis.
Yes.
Commissioner Foster.
Yes.
Motion carries.
All right, moving on to item 12A. Consideration of whether to approve for adoption at the board's November 8th meeting proposed new subdivision I to regulation, is it an I or an L?
L.
L, to regulate, thank you, to regulation 3301 and proposed new regulation 3301A respecting the establishment of base rents for new tenancies after the repeal of the Costa-Hawkins Rental Housing Act. If you folks will line up a couple at a time, that way we can move a little faster. Oh, sorry, after the staff report. My fault.
Good evening, Commissioners. Tonight, the Board is considering whether to approve but not adopt a regulation respecting the establishment of base rents for new tenancies in the event that Prop 10 passes and the Costa-Hawkins Rental Housing Act is repealed. The purpose of approving but not adopting the regulation would be to allow speedy adoption of the regulatory amendments at the November 8 board meeting if and only if Prop 10 appears to have passed on November 6th. Under Charter Section 1804B, a controlled unit's base rent is the rent that was in effect on April 10, 1978, unless a landlord has the right to establish a different base rent under state law. If Costa-Hawkins is repealed, then there will be no state law allowing landlords to establish base rents. So applying the charter's plain language, the base rent for any new tenancy following the passage of Proposition 10 would be the rent that was in effect in 1978. The board has made it clear that it would not apply that definition as written. This is not because the board has a policy preference that it wishes to advance, but because permitting a rollback of base rents to their 1978 levels would likely abridge many landlords' right to a fair return, thus violating both statutory and constitutional law. Although the board's regulations currently provide for a mechanism to ensure that landlords are permitted to achieve a fair return, the repeal of Costa-Hawkins and plain application of the charter could result in too many individual petitions being filed for the board to timely assess each one. In these circumstances, the Supreme Court in Birkenfeld versus City of Berkeley has made clear that the constitutional due process guarantee requires a more across-the-board approach. The proposed regulatory amendments presented tonight would provide such an approach. Charter Section 1802E allows the board to enact regulations that become necessary if a change in state law makes a charter provision unenforceable. Such regulations are permitted only to the extent necessary to resolve any inconsistency between the unenforceable provision and those that are still enforceable, and only to the extent that the new regulation is consistent with the intent and purpose of the unenforceable provision and other applicable law. Therefore, in order to comport with the elimination of the state law right to establish market rate base rents and to preserve landlords' existing rate of return through the 2020 election, the proposed regulatory amendments freeze base rents at their current levels. The proposed regulatory amendments would preserve the base rent increases that landlords have already achieved as a result of vacancy decontrol, and would also lock in 1978 base rents for those units that have never had such an increase. The proposed regulatory amendments do not provide for any adjustments to the 1978 base rents, since there is nothing in the charter that would allow for that post-passage of Prop 10, and it is not clear that such an adjustment would be necessary to ensure landlords a fair rate of return. There are also a relatively small number of units with 1978 base rents that are likely to be affected by turnover within the next 2 years before a charter amendment could be adopted. Because landlords with pre-1999 tenants currently appear to be receiving a fair return, keeping their rents at current levels would not change that, and the individual rent increase petition process remains available. However, if the board determines that an adjustment to the base rent for those units is necessary to comply with a clearly articulated and clearly applicable preemptive law, staff has provided data to inform the board's consideration of how great or how small such an adjustment should be. As discussed before, this proposed regulation does not provide the long-term solution to all problems that a Costa-Hawkins repeal would present, or take advantage of all possible approaches to the rent control law in the absence of Costa-Hawkins. But it would prevent the immediate upheaval that could result until a long-term solution, namely a voter amendment to the charter in 2020, can be accomplished. It is a stopgap measure to avoid the plain application of the charter's definition of base rents that would likely violate constitutional law. Policy choices about whether Santa Monica should continue to have vacancy decontrol or whether there should be a different means of establishing base rents are for the voters. They are not for the board. The board's authority is limited to the implementation of the policies articulated by the voters and embodied in the charter. In addition, because the charter does not provide for vacancy decontrol in the absence of state law requiring it, it would be unlawful to enact a regulation permitting it. To do so would be in direct conflict with the charter's definition of base rent in the absence of Costa-Hawkins. Therefore, staff recommends that the board hear from the public, deliberate about whether it should approve for future adoption only if Proposition 10 is approved by the voters at the November 6th statewide general election, proposed new subdivision L to regulation 3301, and proposed new regulation 3301A respecting the establishment of base rents for new tenancies after repeal of the Costa-Hawkins Rental Housing Act. If the board concludes that it is both lawful and necessary in the event of Prop 10's passage to permit adjustments to units with 1978 base rents, staff recommends that the board deliberate about what such adjustments are warranted and give staff appropriate direction so that staff may draft regulatory language for the board's future consideration. That concludes my report.
Thank you. That was a great report. And we have several members of the public who wish to speak. All right, we'll proceed with public comment. So let's line up 2 or 3 at a time so it doesn't take you so long to get from your seat maybe over to the podium. We'll keep moving. Bill Dawson, Mark Muallen, Kevin Kozal, Linda Lancaster are the first 4.
Good
All right.
evening.
Go right ahead, Mr. Dawson.
Good evening, Commissioners. First off, I want to compliment staff for all the hard work they've done on this, trying to figure out all the nuances. This is a mixed bag and a very difficult issue to handle. Per my email, I want to continue to voice my support to adopt staff's recommendation with one exception. Putting a date that expires, a sunset date on it. 3301A, where it would expire on November 3rd, 2020. I don't think an expiration date's necessary. I think that the board at a future time could end it by regulation just as well as they're considering adopting it. So I think putting a sunset date on it could cause confusion, stress as the 2020 elections are approaching. And I think eliminate that stress as opposed to setting yourselves up for that stress at that time. The last thing I wanted to bring up, I don't know if it's my naivete, I didn't have a chance to call staff on this, but the second to last item, 3301A10E, page 11. I was a little confused on this. Maybe staff could clarify. For any unit with no base rent in effect on the date Proposition 10 becomes effective due to state mandated vacancy decontrol, the base rent shall be the last base rent in effect for that unit. I don't know if I misunderstood that, but if there's no base rent, how could it be the last base rent that was in effect? So just throwing that out there. I don't know if maybe I'm misunderstanding that.
Go ahead, Tracy, if you'd like to answer. If not, he can take his conversation with staff offline.
Okay. Thank you. That concludes my comments.
Well, just in case there are others that are confused by that, what we are intending is there are some units that are currently owner-occupied or family-occupied or subject to Section 8 and therefore do not have a rent control established base rent. Those units, if they were no longer so occupied, the rent that would be in effect would be the rent or the base rent that had been in place for the prior tenancy that was subject to rent control.
With adjustments?
With adjustments, yes. Thank you for that correction. That's important.
All right.
You want to add anything?
Thank you. Mr. Muallen.
Thank you. This issue requires both the consideration of the legality of 12A under the current Santa Monica Rent Control Charter, as well as whether 12A would fulfill the legal requirement of allowing housing providers to achieve a fair rate of return. 12A would prevent housing providers who have made recent investors from losing their investments entirely by ensuring they'll be able to continue to get the same rent from their next tenant. The passage of 12A is legal due to the necessity to prevent an across-the-board removal of the ability of housing providers to make a fair return. On another note, rejecting currently accepted base rents would likely be illegal in itself, as an accepted tenancy registration may be understood as legally binding. Secondly, does 12A allow for a fair rate of return? At purchase time, properties make an ultra-low rate of return, if not a loss. Housing providers make their return through the appreciation of a property caused by the adjustments of rent to market rate over time as tenants move out. For investors who have recently purchased their properties with the expectation that upcoming vacancies will allow for a fair return, 12A does not address their right to make a fair return. However, for housing providers who have purchases are less recent, respecting said rent adjustments would go a long way in ensuring fair return. So while 12A does not entirely fulfill the legal requirement to allow for fair returns under vacancy control, it does make progress in doing so. Lastly, I want to address Section 3B of the 12A memorandum. The absence of rent increase petition proves only that housing providers are not applying for rent increase petitions. One possible explanation, as brought up in the memorandum, is that housing providers are already receiving a fair rate of return, so there's nothing to do. Another explanation is that Santa Monica housing providers, particularly those who fall under the category of small businesses, do not have the means or know-how to navigate through the legal process. Another explanation is that the formula for determining rates of return does not encapsulate the full range of costs. As a result, housing providers do not believe they can successfully argue for a rent decrease under these constraints. And another explanation is that the process is so time-consuming and costly that what the law defines as fair return is not sufficient to incentivize the process. In all likelihood, it's probably a combination of all of these explanations. The truth is, housing economics are incredibly complicated. But if we're going to solve the housing crisis, we must think critically about the policies and regulations we pass. Thank you very much.
I believe one commissioner has a question for you. Commissioner Tarosis. No, she's in for discussion. Commissioner Tarosis has a question.
Have you ever come to the board to petition for a rent increase on any of your units?
Nope.
Okay, I would ask that you avail yourself of staff to educate yourself on the process to file for a rent increase, as I don't believe that it's as complicated as you're making it out to be. Whether or not you'd like it to be a different process, that's a different comment.
I have looked into it, and I got a lot of expertise in real estate, and I've asked other landlords, and we're all pretty confused about it. So
okay, well,
I'd like to know a way to learn more.
Great. We have Mr. Costello here who can answer any of your questions that you have, and we can also try to make office hours available to you.
Thank you for pointing that out. I really appreciate it. Have a good night.
All right. Thank you, Speaker. Mr. Kozel.
Good evening. Kevin Kozel, 1256th Street. I'm speaking tonight on behalf of the Santa Monica Housing Council. We support the substance of the regulation proposed by staff. Our concern relates to the sunset date and the temporary nature of the regulations. Staff's recommendation on the regulations being temporary is grounded in a concern that Section 1804B will require a rollback of base rents to April 10, 1978 if Costa-Hawkins is repealed, and therefore a charter amendment will be required in 2020. We respectfully disagree with that legal analysis. We believe that the proposed regulations reflect the most reasonable interpretation of Section 1804, which is in the event Costa-Hawkins is repealed, though the rents, the base rents will be those rents in effect on the effective date of Costa-Hawkins repeal with no rollback in base rent date to a previous date. This interpretation is consistent with the standard rule of statutory construction that laws are to be interpreted constitutional. And as staff has indicated and acknowledged, a rollback to April 10 in 1978 likely would be unconstitutional. If Costa-Hawkins is repealed, nothing in Section 1804B on its face, nor in Proposition 10 itself, mandates that Costa-Hawkins rent increases that were previously legally taken have to be eliminated. And we don't believe they will be eliminated, and consistent with Mr. Dawson's comment, we would support adoption of the regulation without a sunset date. And then finally, for the record, I want to be clear that the Housing Council supports vacancy decontrol. And if it were the case that your legal counsel indicated that with Proposition 10 being adopted, you could legally adopt a vacancy decontrol regulation notwithstanding the charter, we would certainly support that. But we don't believe that is your legal position, and therefore we support adoption of these proposed regulations without a sunset date. Thank you.
I have a question, and a couple of us, I think, have a couple of questions really quickly. I read your accompanying letter. It was well written, and your views were clear to understand, and I appreciate you writing.
Thank you.
The Santa Monica Housing Council, is that a club or a PAC or?
It is a nonprofit
501c3?
It is a 501c3.
I hadn't heard of it, so I was just looking for clarification.
And I question it because I'm not sure where our tax exempt status was. I think it lapsed and we're reapplying.
So it's new?
It is an old corporation. It was incorporated many, many years ago. It follows Santa Monica housing regulation issues. It's been involved in some lawsuits against the city of Santa Monica on housing issues. And I believe it is a 501c3. The tax exempt status may have lapsed, and we're clarifying that.
Okay, because I looked and I couldn't
Yeah.
find a website for it except that it said local government office in Santa Monica, and I was pretty sure wasn't familiar with that one. But thank you very much
You're
for
welcome.
clarifying that. Commissioner Trosas has a question for you, and Commissioner Phyllis.
Who comprises the Santa Monica Housing Council? Like, how do you become a member of the Santa Monica Housing Council if I was interested?
Well, under California nonprofit law, there's two ways that you can have a nonprofit corporation. You can have one with members,
Right.
and that's similar to a corporation that has shareholders. There's also nonprofit corporations that do not have members, like legal voting members, and then you can form the corporation. You have a board of directors, and
So who's on the board of directors?
it's Bill Dawson, Joseph Fitzsimmons, Robert Sullivan, David Hibbert, and Irma Vargas.
Okay, great. Thank you. That's helpful. Thanks.
Commissioner Phyllis?
So again, these questions pertain a bit to the Housing Council. So you mentioned you're a nonprofit public benefit corporation. You don't have voting members or shareholders, but you do have a board of directors.
Correct.
And those board. So can you just how many directors do you have on your board?
I think I just named them.
They're
think it's
five, like
or
about
six,
five.
yeah.
Okay. How many of them are housing providers?
I don't know off the top of my head.
Do you know what the occupations of any of them are?
In the real estate business,
Okay. And are you registered as a lobbying firm or lobbying body with the city of Santa Monica?
I'd have to double check on that. I'm not sure.
Would you consider this a lobbying activity?
We're speaking on behalf of a proposed regulation.
Okay.
Okay. So next will be, thank you for your comments.
You're welcome. Thank you.
Next will be Linda Lancaster, followed by Rosario Perry and Jay Johnson. And we'll call the last couple names after that.
Okay. Hi, my name is Linda Lancaster, and I live in the Mid-City neighborhood. I own a rent-controlled duplex in the Pico neighborhood. And I met some of you the other night at Squirm Night, and it made me think, and I did a little research this morning, and that's why I'm here tonight. And that's why the first PowerPoint sample says, a sample of Pico neighborhood rental buildings requiring earthquake retrofittings that have low MARs. So what I did was I went onto that website. This is the first page. There's 1,700 buildings that need retrofitting. And the second unit down was listed on 17th Street, and that's not far from the duplex that I own. So on the next 3 pages, I identified 8 properties that were close to my property, all in the Pico neighborhood. And I went to the rent control site and looked up the rents for those properties. And I've chosen to show you 4 of them here. This is the first one, 1943 17th Street. Look at the MARs. The highest one is 1474. There's an exemption, and the lowest one is 701. This is what the property looks like from the front and the back. You can see where the soft story retrofitting will occur. The next property is 1754 Euclid Street. Again, there's an exempt unit, assumably for owner occupancy. And you see that those rents range from about $1,000 to $1,200. All of those units are 2-bedroom units. And this is what that property looks like.
Ma'am, not to interrupt, and I'm going to hold your time. So does this pertain directly to Costa-Hawkins repeal?
Yes.
Okay. I just wanted to make certain because you were talking about earthquake
I know it's
side.
not 12C.
Okay.
Although if you want to use this data for 12C, please feel free to do this.
Okay. No, I was just clarifying.
Yeah.
All right.
So I went out and took these pictures this morning. Had fun doing that. And when I looked at this building, it looks like they need front and back retrofitting. That could be a lot of money. I looked at 1846 9th Street. And this is a really interesting property. There's 5 units. 2 of them look like they're exempt. Actually, all 5 are condos. And the 3 units that have MARs are rented out. And when I looked at the All of them had been purchased before Costa-Hawkins, except for Unit 5. It was purchased in 2012. And it was purchased for over $500,000 with a mortgage of $1,417,000, which works out to almost $2,000 a month, $1,990 to be accurate. That doesn't include taxes, condo fees, insurance. So this person is subsidizing who's living in there that must have been in there pre-Costa-Hawkins. And this is a picture of that building. Again, you have a front entrance and back entrance, and there'll be a lot of cost to that building for retrofitting. The last one that I looked at, 1911 Euclid, again, you'll see that the MARs are quite low. And if there was any building of the four that I would bet on that's going to come down in an earthquake, it's this one.
That was your 3 minutes. Do you want to quickly wrap up with?
Yeah. My point is,
I would like to give you the opportunity to quickly wrap up.
Yeah, my point is that if you do not allow these buildings that have low rent that will have to retrofit their building if Proposition 10 passes, and you only allow a small increase on base rents, these are the buildings that are going to be sold and going to be Ellis'd, and these are the tenants that you're going to lose in this city.
Thank you for your comments. All right. All right, moving right along, Mr. Rosario Perry. Folks, I'll ask you to hold your applause. Thank you.
Good evening, Rosario Perry, 312 Pico. I sent a 2-page letter. I don't know if you got it. I sent it late, but thanks. So you read it. It's a big number, and for people who have not read my letter, I estimate, and I did it a number of ways, owners have probably given tenants approximately $500 million in relocation fees to vacate. Okay, and no one believes it. That's more. It's almost as much as the city budget for 1 year. And so, how do we do that? Well, we know we have 20,000 vacant units, and we know that a lot of these units turn over. So, if someone was a vacant unit in 1999, he rented it. He might have a vacancy in 2005. He'll re-rent it, and then to get that tenant out, sometimes they pay these they pay these bonus move-out costs, and I refer to that as as an equity right of the tenant to receive these buyouts. Because if a tenant's in a unit and has a lower rent than an owner can get at market, that tenant can sell his right to vacate. Many times the tenant is moving for other reasons, such that they have to go to a rest home. Their senior citizens are moving to a rest home. They may want to move out of state for job employment. They may get married and they want to move up or out. So if the tenant leaves without a bonus or equity bonus payout, he gets nothing. If he can move and ask the owner for a buyout, he might get $25,000 to $50,000, something in that range. That helps them on their move. Now, if you get rid of vacancy decontrol, and we have a low tenant, we have a tenant there who's getting $800, $900 a month rent, his equity buyout might be $50,000. But you've stolen that from him by not allowing vacancy decontrol. Because if an owner has an $800 rent and the tenant's going to leave, and he can't raise that rent under your regulations, he won't be able to, because that's the base rent, or that's the adjusted base rent. It's all he can get when the tenant vacates. He's not going to pay the tenant anything to move, because he's not going to get any upside in the rent. Now, can you do this legally? Staff says you cannot adopt vacancy decontrol. I say you can for 2 reasons. One, the charter allows it, and if you just read the charter with a liberal reading, you can find that. But more importantly, the state law allows it. And we're talking about Prop 10 now. If Prop 10 passes, it has an A and a B section. Section A has been completely ignored by staff in their opinion letter to you, and I don't know why. But Section 8 says that a city shall have the authority to adopt by regulation a regulation that governs a landlord's right to establish and increase rental rates. Now, what does that mean? It means the state law is preempting the charter. The state's law is giving the board the authority to adopt rules or regulations to adjust rents as you see fit. And that is vacancy decontrol. And you did that once before when there was an Ellis. If you remember when the Ellis Act passed, it preempted local laws. And what it did, it said owners can evict all tenants and go out of the rental business. This was 1986. I'm sorry, can you just have 15 seconds?
There's a question for you from a commissioner.
Mr. Perry, thanks for your letter. I read it. You're an attorney who primarily represents landlords. Isn't that true?
Yeah.
And how many buyout agreements have you personally facilitated in your career?
Maybe 200, 300.
So your livelihood is in part based on buyout agreements continuing, correct? Okay, that's fine. All right,
Maybe,
thanks.
Maybe.
Thank you for your comments. Mr. Johnson, followed by Mr. Wang, and finally Mr. Pat Kramer. Mr. Johnson, you have 3 minutes.
Thank you. Jay Johnson, 601 9th Street. A simple plan. My argument is that you should not adopt these regulations tonight and in place put in a simple plan. If Proposition 10 passes and subject to an injunction if granted and effective 90 days with 90 days notice in effect February 2019, the following. Upon vacancy, rents can rise to the average of the rent control zone or neighborhood map that has been established, but no less than the 2015 average rent level of one bedroom at $22.48 and subsequently the 2 and 3 bedroom that are on the chart that the rent board has issued. In addition, it would be added the repairs and improvements with a 5-year amortization on short form with a permanent upcharge with no drop-off. Furnished units would be slightly higher. That would be the simple plan. In addition, I would argue that the notice requirement of 90 days is critical. There's a number of vacancies that are in process at this time that are being improved, repaired, and not yet re-rented. The landlords, property owners, property providers need notice to make adjustments to what the new plans are. Showing the turnout tonight, I would argue that there's many landlords in the city that are not aware that they would not be able to raise rents come early November of next month, and that there would be significant items in process and a great deal of money being spent rehabbing, improving units. Secondly, I would argue that the increased petition, which is discussed at some length inside the staff report, is a misunderstanding, I would argue, as to interpretation. It needs, number one, a survey of property owners and landlords in the city that have either considered or otherwise have not considered doing increased petition, and to show you in black and white that it is an onerous process. It needs to be completely restructured. The amortization periods need to be shrunk, reduced way down to where they had been expanded early about 15 years ago to make it more useful and to be incentivized to actually be used in those cases. The pure argument that because no one has applied, therefore no one needs it, is totally disingenuous in my humble opinion. Number three, the idea that the rent board cannot set policy that's in contradiction to the charter, I would argue is a very thin line between setting new regulations and establishing policy. That in fact, to most people, new regulations are policy. They're implementation policy, in effect, called regulations. And lastly, the constitutionality of what we're talking about here tonight really is open question for the courts to decide. Simply saying that is unconstitutional, I feel is very problematical, given the one decision that is quoted in the constitutionality issue, and given so many things that have happened in the 30 years since that particular decision was issued. I would argue that the courts today would have a different view on constitutionality. Thank you.
Thank you, Mr. Johnson. All right, Mr. Wang, you have 3 minutes, followed by Mr. Kramer.
Wang, W-A-N-G. Thank you. It's a picture of my little boy a while back when he's in early elementary school. One day he came home at early part of his academic career. He was very proud that he got 100%, his first 100% mark. And I said, good job. And with that, he continued working very hard, no video games. Tough for a little boy. And then one night, just to see what he will do, I said, son, are there a lot of kids in your class that don't do work like you and maybe goof around a little bit? He said, yes, they don't do any work at all. I said, for social equilibrium, why don't we take 50% of your score and give it to them? And he said, with tears in his eyes, what that's unfair? Social emblem, why social equilibrium? I said, I'm just kidding, son. A few days later, I heard him talking with his little friends. Hey guys, let's play video games. Let's not do our homework. I can convince the teachers to give us more points. It's called social emblem. I took him home that night to the back. I said, son, that's not how it works. In life, your position is based on your hard work and the limits of your imagination. I hope you grow up, be prudent, be judicious, have temperance, and maintain your fortitude. Sir, I'm asking for your attention, please. And all I ask for him is that he grow up, also maintain his faith, his hope, and be charitable because he is blessed. I believe Santa Monica is a place where creative ingenuity will be coming. I hope that you can solve these problems of this proposition. I think in this city, my personal view is that there is only a minor position that has medium density. I think you can transfer much more air rights development or FARs to other parts of the city. Increase housing stock. Do not force the market in disequilibrium. Especially punish the few families out here that owns properties when there's greater social issues at hand. In microeconomics, there's a balance called Pareto optimality. I think you can achieve that. Thank you. Good night.
Thank you for your comments. Mr. Kramer?
He still works hard, doesn't play video games.
My name is Pat Kramer. I was surprised by the staff report. I don't know how many rent control staff have looked at their own report, but it's significantly different from the September 13th report. I mean, it looks like you have a new attorney. The staff report dated October 11th is a totally different conclusion. Specifically, on page 6, it says, adopt a hybrid approach. That was an alternative for, this is on the September report. This was an alternative for the rent board to consider. It gave 4 freezes, and it said there are numerous other alternatives. Specifically, it covered units that never had a cost occupancy increase. These units that are 550 or 600 or something like that. And I thought, God lives. Finally, after 35 years, they're going to address this situation. That's not the case. In the October 11th report writes on page 5, it states that because no one files for an increase, it must indicate, and I don't think this is a legal opinion, I think this is just a plain old opinion, but they're saying no one files, so everybody in the city gets a fair return. That is really crazy. That is, no one files because everyone knows it's worthless to file. The second thing it has in there, that it's a very small number, and they mentioned basically 1 in 4, 7,100 units. Maybe it's a small number to somebody writing that report, but it's more than all the units the Community Corp has. It's more than all the units that have been Ellis combined. It's a lot of units. So what do we have? We're now the report, not what was being told in September. Now we're being told can't do it. This is an opinion. This creates a disaster. My hope is that you will not end up with a whole lot of buildings vacant, a lot of units vacant, especially small buildings. They're going to go out of business. You're going to lose them. The earthquake work, that's going to be history. You're just not going to. It's not going to be done. Why would you do earthquake work when you have low rent units? And Ellis is not going to disappear, and there's going to be no deal. Owners are not going to have their tie in. If you rent one at a low rate, you'll get to rent one. Nobody would put a lien on their property doing that. So if you want to encourage no repairs, no signs, and owners to violate the law and try Airbnb, that's what's going to happen. But look again, maybe throw out the October report and read what you were talking about in the September report.
Thank you. Thank you. Thank you for your comments. All right, that concludes public comment, and we're going to enter discussion. Commissioner Phyllis, you're in the queue.
So I first want to, before we get into the substantive portion, I think there's something that I've seen City Council do and members of the Planning Commission do, which I think is always actually helpful, particularly on something like this where we're being lobbied by a lot of members of the public. And I'm going to share, and I would encourage my fellow board members to share any disclosures of communications that they've had with members of the public. And I think it's just helpful for transparency's sake to see who we're talking to, because I think there's a lot of perceptions about who we're talking to. And this will, I think, kind of speak to that. So today I had a conversation with Mr. Jay Johnson, with Mr. Pat Kramer prior to this board meeting, and Ms. Naomi Sultan from a variety of sectors. And then about 2 weeks ago, I also had a conversation with Councilmember Sue Himmelrich regarding this measure and regarding
our measure or Costa-Hawkins repeal?
Regarding potential stopgap measures, basically, if Prop 10 passes, what we would do as a board. So there are a couple things that I want to talk about, why I think we need to pass this tonight, and then what the next steps are. I think we need to pass this tonight because the alternative is, if we don't reach consensus on at least a base level, that we will be faced with rent rollbacks in November. Our next board meeting is not until November 8th, which means that this is the last board meeting we have before Prop 10 potentially passes, which would be effective on passage to prevent rent rollback. So I think it's really important that we act judiciously and carefully tonight. That said, we're going to have an enormous amount of work to do, including between now and 2020, if there's going to be changes to our charter amendment, and also if there are going to be interim adjustments regarding these particularly historically low rent properties in the interim. That's, I think, something that is going to require more attention and more time on a going forward basis, and a decision that I'm not sure we are empowered to do, but I'm open to hearing from members of the public. What I am absolutely certain we are empowered to do is to enact basically a regulation that would preserve the status quo. And I think that's the most prudent and responsible thing if we're doing here tonight. I do want to make clear that for historically low rents that do become vacant, I realize this is not a perfect fix to any solution, but there's also the availability of Section 8 housing. Is that correct? So if there's a historically low rent that's lower than what a Section 8 rent could be, a housing provider could choose to offer it to a Section 8 tenant. So, I mean, if you have a $650 rent and you would be limited in terms of a 2018 increase with an incremental increase after that, you could in turn elect to take in a Section 8 tenant, which I believe a one bedroom is around $1,900. Okay. So look, we're really trying here. We're trying to, have a stopgap measure that preserves the status quo, that is within our jurisdiction, that's within our authority, without overstepping our bounds, and really work toward consensus, particularly for 2020, where there are a lot of issues that we're going to need to address. There's, I think, also a lot of concern about, things that would potentially happen in 2020. I don't think now is the appropriate time to address those issues because they aren't before the board tonight. But I would encourage members of the public to talk to their board members about, issues like, is there any interest in controlling single-family homes? I certainly don't have any interest in doing that. I'm not sure if my colleagues have any interest in doing that, but I think there's a lot of misconceptions about what's going on in the community, what the potential impacts of Prop 10 would be. And, I think it matters who your representatives are. That's just one example. I'm not going to go through all of them because it's not before the board tonight. The other issue is this, is the issue with the staff report about what can we infer, if anything, that housing providers aren't providing for a fair rate of return. And while I agree with, I would say, 95% of the staff report, I don't think that we can infer that simply because applications have not been filed, that automatically landlords are or housing providers are making a fair rate of return. I think there's a lot of evidence aside from that suggests that landlords are making a fair rate of return, and that was also discussed in the staff report. And I think kind of the gestalt effect is why the staff report arrived at that conclusion. But I think it would be helpful to see, particularly for some of these properties with historically low rents, if walked through the process of the NOI process, if there is a differential, if property owners aren't making a fair return, because I know that the board members here are committed to that principle about making sure that housing providers make a fair rate of return. And it's concerning to me that we haven't had any applications in 5 years. To me, that's a red flag. Whether it's people don't know how to use the process, whether it's people feel like the process isn't worthwhile. But I don't think, given the lack of data in the last 5 years, we can infer much just based on that fact alone. And then I do want to say, with regard to the retrofitting issue, this is something that I think will come up with regard to Regulation 12C, but it's something I do think the board is paying significant attention to, and will be working closely with City Council to address many of the concerns, particularly the concerns with regard to properties with four or less units, so smaller properties, because we recognize that some of the financing and cash flow issues for the smaller properties are fundamentally different than properties with 20, 30, 40 units. So thank you again for your attention tonight.
Commissioner Terosas.
I, like Commissioner Phyllis, think that a lot of misinformation has been kind of propagated and continued to mushroom out in the community about what we're doing here and what Proposition 10 entails. I think that we are taking the prudent steps, and in fact, I have been concerned about this since we heard that Proposition 10 was going to be on the ballot, in order to make sure that we don't have rent rollbacks, in order to protect a lot of our landlords. We understand that there are long-standing landlords in this community, a lot of whom are small mom-and-pop landlords. We have in the staff report the number of units that the majority of these landlords have control over. It's a very small number, and we want to protect those individuals and ensure that there are not any rollbacks of the existing rents. So with that in mind, I mean, I'm 100% supportive of the recommendation in the staff report. Whether or not we are entitled under the charter to put forward these regulations, I believe that we are. I believe that this is the best solution that we have, and I do believe that this is necessary in the event that Prop 10 passes. We ensure that there are no rent rollbacks. I actually am inclined to agree that the expiration date is not necessary. I think that we don't know what's going to happen in the future, and I think that just limiting yourself to an actual date makes us have to come back and reevaluate this issue. So if and when we decide to put something on the ballot, we can decide at that point. I also don't have any interest in going to the voters to try to change the charter to try to put single-family homes under rent control. I've heard a lot of that people are very concerned that their home is going to come under rent control. That is certainly not the appetite of anyone on this board, or excuse me, of at least two of us. I don't want to speak for anyone else. That would not be a judicious use of my time, and I want to make sure that we're working closely with both tenants and landlords to ensure that we're doing something that works in light of this very consequential ballot initiative.
Commissioner Duran.
Thank you. There was some very well thought out comments made tonight. Thank you all for coming tonight to express your opinions and concerns. I've listened to them all. I think that one of the big concerns about what we're doing or trying to do tonight is that stopgap measure should Proposition 10 pass. And I think and agree with my fellow commissioners here that the prudent thing to do is to do something to prevent a complete drop in the economy, in the rental market, should Proposition 10 pass. I mean, I think to do nothing would be a problematic issue. So having said that, that at least keeps the status quo for the next 2 years, which gives us time to consensus build. As you've heard people say, you know, there's differing opinions about what solution we should use or we should approach, and not everyone's going to be happy. I mean, I think that that's something that we all have to start wrapping our heads around. There's not going to be a solution that is going to please everyone, but what is the solution that we can all swallow such that we can continue to live in this community? One of the things that I've mentioned before, and one of the goals of rent control is to stabilize the community, right? And you've heard the phrase to age in place. And more times than not, that is a reference used in regard to tenants, so that tenants can age in place. But I believe that it's also true for landlords. We want good landlords to age in place as well. And we don't want to do things that is going to end that. So I'm inclined to eliminate the sunset provision. I think it makes sense such that we're not making an emergent situation potentially right before the 2020 election, so that we have time to really consider what best options are and a consensus build. Those are all my comments at this point. Thank you.
Thank you. So someday when I'm no longer chair and get to go first or second or third again, I'll get to wax poetic about how I feel about all these things. But it's customary for the chair to save their comments for last, and I don't want to reiterate or rehash what my fellow commissioners have already said, though I really want to. I appreciate, so I get to philosophize. This room has looked like this, over half full. We've even had standing room only in the last few months. And after 3 years up here on this dais, I can tell you that's the first time in my career up here that we've had this sort of participation from the public and from property owners and tenants. And we really, really appreciate it because, knowledge is power for all of you and for all of us. And the more of you who participate, the more we all take in and we learn and we get exposed to new and different points of view. So we do appreciate all this participation and interest that we're seeing. It makes a difference. A couple things I heard tonight that I want to clarify. We hear a lot about rising costs as a property owner. So in the spirit of Commissioner Phyllis's recommendation, I have spent an inordinate amount of my time in my private life researching this issue and talking with everyone from elected officials to property owners and numerous tenants. And I have I've spoken with Pat Kramer. I've spoken with 2 other landlords just this week, and one the prior week who I don't have their permission to reveal their names, so I won't do that. But 4 landlords in the last week and a half with long, substantive conversations about real issues that are important. And there are competing interests here. There are competing scenarios. And I don't think anything we decide up here will entirely please every constituency or every stakeholder out there. There are small property owners, large property owners, people who've bought recently who are under different economic pressures than people who bought a long time ago or perhaps inherited a building. There is such a vast spectrum of tenancies and owners out there. I think there's some confusion sometimes about what this body is tasked with doing. We only administer the rent control charter, and it's our job to follow the law as a quasi-judicial body and as a regulation-making body. We don't change the charter. The five of us cannot change the charter. Only the voters of Santa Monica can. So if things that get recommended from here, recommended to council and go to the ballot aren't what the public agrees with, then they won't vote for it. That we cannot, I think people think we can do things that we simply cannot. And to be completely practical, if we did something that was not legal, we may try to do it, but we would be sued by one individual and it would be overturned instantaneously, thereby invalidating the effort in the first place. So I will say, with rising costs and things considering not being able to raise, vacancy decontrol anymore, perhaps, if this does pass in November and if we put the stopgap measure in place, staff, is it not correct that when we adopted Measure GA and chose to use 75% of a 5-county average CPI, I read with great interest the old staff report from that year that said that over 30 years of haggling and bringing in receipts and negotiating with a spectrum of owners, a committee really, to establish what costs were each year, that in fact the 75% of CPI that we use now mirrored almost exactly a 30-year average of those cost increases year over decade over year. Isn't that correct?
Well, that is correct. And when we had the old formula before Measure GA, it required us to gather as much information as was available about increases in owners' operating expenses. Not a lot of information is publicly available for that. So a number of those pie components were adjusted by a factor of the Consumer Price Index. So it was somewhat driven by the Consumer Price Index, even though we were doing that analysis of actual increases in expenses. But it is true that over the 30 years that we did the general adjustment analysis, that it usually worked out to be about 75% of the change in the Consumer Price Index, which is why the board then elected at that time to put that before the voters.
Thank you for that clarification. And again, not every owner's expenses or insurance policy price is going to be the same. But this was the most equitable catch-all we could find, and it mirrored 30 years of data. So I'm comfortable with that at this time. Also, I'll go on the record as saying I have no intention. So that's 3 board members who have no intention of doing draconian or drastic measures should this come before us in discussion over the next couple of years. There's been a lot of panic and I've been on social media trying to answer people's questions faithfully and honestly. I've been beat up on those forums, and that's okay. I didn't have to speak up and try, but I did. It's not easy to talk with people about it, but a lot of us are willing to do so. And we've signed up for this, so we will continue to hear you and to converse with you about these issues. I'm also okay with honoring the request I've seen in 2 well-written letters this week. I checked with staff for my own personal edification. Taking out the expiration date does not affect the validity one way or the other of what we're attempting to do tonight, which is to stop any rent rollbacks and to preserve what I think the data suggests is a pretty healthy market rate distribution of rents among buildings. And if anyone is experiencing anything less than that, then we have the staffing to accommodate you. You may come in and ask anytime you want what your roles look like. And that's from here and on forward. And if you disagree, I apologize, but it's also codified in statute and not something we can change. It's a mathematical formula. So that's not something the 5 of us or any of the people sitting to my left can dictate. It's in the charter. So that's up to the voters. It's not up to us as a rent board. So I just wanted to clarify that in case there was a question. So I think we've talked this thing out, and I would entertain a motion that includes removal of the expiration date if somebody would like to make one.
Excuse me.
Oh.
But we are asking just that you indicate your approval for these, not adopt them tonight, because it is all contingent upon what
but in
happens
gathering,
with Prop 10.
thank you for the
Yes.
clarity. But in gathering consensus,
Yes.
for my vote, it would be to adopt staff's recommendation, but with the caveat that we remove the expiration or sunset date, so as not to create confusion or a sense of urgency yet again, should this come to pass. Do we just need consensus tonight, staff? Yes. Not a motion?
Concur with that.
You can make a motion to approve these in concept, and then to adopt, you would adopt them at the November meeting if Prop 10 appears to have passed. That's the recommendation.
I thought it could go
not
into
to adopt
effect
them this evening.
I find that problematic because we would be adopting isn't the point of this to adopt regulations before Prop 10 passes?
Prop 10 would not go into effect until after the election is certified. So owners, there would be time to do that. And we won't know, I mean, hopefully we'll know on November 6th. That's what the recommendation is.
Is there a public hearing requirement since it's enacting a regulation?
Well, you're holding, I mean, all of your meetings are public, and you're hearing from the public this evening. We would hold another opportunity on the November 8th to do that.
I see. So we could call it a public hearing on November 8th, and we could pass it or not that night.
Correct. You would adopt it that night. That's right.
Okay. Do we have did you make a motion, Commissioner Trosas?
Well, I was going to move to direct staff in the event that Proposition 10 passes to prepare the attached draft regulations, with the exception of striking the language for a sunset or for an expiration date for our adoption at the November meeting. Does everyone agree with striking the expiration date?
Yes.
Okay, great.
All right. It looks like we have consensus. Do you want to do a roll call?
Is there a second to that motion?
I'll second.
Clerk?
Commissioner Trosas?
Yes.
Commissioner Duran?
Yes.
Commissioner Phyllis?
Yes.
Commissioner Foster?
Yes.
Motion carries.
All right. All right, moving on to 12B, the board will consider whether to adopt a proposed new subdivision D to Regulation 1003, respecting the circumstances under which commissioners may participate in a board meeting by teleconference.
Who's preparing the staff report?
All right, let's hear from staff.
Okay. The question before you on this item is whether commissioners should be able to attend board meetings via teleconference, and if so, under what conditions. When deliberating about the circumstances, if any, under which commissioners may participate in board meetings via teleconference, the board should weigh the reasons for or against permitting the practice and the degree to which it fosters or impedes public participation in and oversight of the board's activities. Although the board is a legislative body for purposes of the Brown Act, it is not a legislature. As an administrative agency, the board does not, strictly speaking, enact legislation. Rather, it possesses what the courts have described as quasi-legislative or rulemaking authority. It can enact regulations, not ordinances or statutes, only to interpret or implement the city charter provisions that the voters have tasked it with administering. As such, the board does not set public rent control policy. The city's voters created the public policy by their enactment of the rent control law. The board's quasi-legislative function is not to adopt new and additional policies, but to interpret and implement the policy that the voters have already articulated. So, when the board takes an action, whether that action is ruling on a petition or application or adopting a regulation, it is not asking what policy do we want to foster or create. It is asking what interpretation of the Charter's rent control law will best effectuate the voters' intent, or how will this implement what the voters have mandated. Because the board may act only by agreement of 3 commissioners, answering these questions is necessarily a collaborative and collective process. Because the board can act only collectively, there's no business that may come before the board to which any one commissioner is essential. Unlike members of a legislature with plenary or police powers, commissioners of the board are not expected to, and indeed cannot, sponsor legislation to advance a policy. They are not called upon to make a case for or against a public policy that they or those who elected them would like to see adopted. Rather, they are called upon to collectively administer the public policy that the voters, in their capacity as sovereign, have already legislated into the city charter. No individual commissioner has any independent authority or policy-making or policy-advancing role, and there is no indispensable commissioner. Accordingly, there's no business that could come before the board that could not properly be and efficiently be conducted in any individual commissioner's absence. Given this fact, there's no necessity to permit commissioners to participate in board meetings via teleconference. But even if permitting the practice is not compelled by necessity, it is a choice that the Brown Act permits it to make. The question is not whether the board can make that choice, it clearly can, but whether it should, and if it does, whether it should impose any restrictions or limitations beyond those that the Brown Act already imposes. The Brown Act begins with a legislative declaration that the public commissions, boards, and councils and other public agencies in this state exist to aid in the conduct of the people's business. It is the intent of the law that their actions be taken openly and their deliberations be conducted openly. The people of this state do not yield their sovereignty to the agencies which serve them. The people in delegating authority do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so they may retain control over the instruments they have created. On its face and considered alone, this declaration includes nothing that would suggest any reason for any limitation on commissioners' participation in board meetings by teleconference. But the Brown Act also requires the board to allow the public to directly address it and to allow the public to be physically present at its meetings. Taken together, these provisions evince a requirement that the public must be allowed to observe the board in person and be permitted in person to address it. The public that presumably has the greatest interest in observing the board and its individual members is that portion of the public that is affected by what the board does, those who live in Santa Monica or own controlled units here. The farther a remotely participating commissioner is from the city, the less likely it is that any member of the public that the board serves will be there to observe him or her. One need not go too far before the likelihood is so small that it is nearly non-existent. If the Brown Act's minimum requirements create an opportunity for Santa Monicans to observe a remotely appearing commissioner that is more theoretical than real, whether those minimum requirements are sufficient to serve the board's Santa Monica constituency is at least a serious question. One possible means to address that question is to impose some geographic limitation on the distance from which a commissioner may teleconference into a board meeting. At minimum, it is inadvisable for commissioners to teleconference from outside of the United States because the Brown Act requires that any teleconference location comply with the Americans with Disabilities Act, and it would be difficult to ensure that compliance at compliance at locations outside the country. Because tenants in rent-controlled buildings live in Santa Monica and many owners of those buildings live in or near the city, some members of the public and at least one commissioner have expressed the view that all commissioners should be physically present at any board meeting in which they intend to participate. This way, the public can observe commissioners' conduct and facial expressions for signs that they are listening or that they are not. On the other hand, a majority of the board has expressed the view that commissioners should be able to participate in meetings via teleconference when circumstances make their in-person attendance impractical or impossible, but there should be rules describing what constitutes a necessity to participate remotely and ensuring that such participation remains an exception to the rule of in-person attendance. Other jurisdictions in California have taken a wide variety of positions on this topic, ranging from broad permission for teleconferencing, subject only to the limitations of the Brown Act, to outright prohibition of teleconferencing, with a multitude of variations in between those two ends of the spectrum. Several examples of those variations are provided in the written staff report for this item, such as geographical limits, descriptions of what constitutes necessity of remote attendance, and rules regarding advance permission from the board. If the board chooses to allow commissioners' participation by teleconference, it should adopt that policy by regulation to ensure consistent application of the policy and avoid ad hoc decision-making when a commissioner desires to attend a meeting remotely. Given the variety of conditions the board may wish to impose, a number of alternatives for regulatory language are provided as an exhibit to the written staff report. Staff recommends that the board hear from the public, deliberate about whether it should adopt one of the alternative versions of proposed new subdivision D of Regulation 1003, respecting teleconferencing, or some variation thereof. The proposed alternatives would permit commissioners to participate in board meetings by teleconference subject only to the requirements of the Brown Act, permit it with conditions in addition to those specified by the Brown Act, or to forbid it. That concludes my report.
All right, thank you very much. We have one late chit. The speaker is only requesting 1 minute. I'm inclined to accept it. All right, Mr. Mualim, you have 1 minute. You're welcome.
So I just wanted to say, so I run my whole business off this thing. I mean, I love technology. I don't know how anyone did anything without it. But I will say, seeing you guys face to face, technology just doesn't replicate that. And I learn and I grow from a lot of the things you guys say back to me, as well as getting the opportunity to share my my opinion. And I think my opinion evolves from having you guys here. So, but I also understand that you guys want to have lives outside of this, and in order to allow working people to serve in politics, there has to be some kind of sensibility in the law. So that means maybe do accept this, but provide regulations that would maybe once per turn, or some kind of proof that it's really out of your control. You have to, miss that meeting. That's all. Thank you so much.
Thank you. All right, Commissioner Phyllis is first in the queue to speak.
Thank you, Chair Foster. So I know I was one of the commissioners who had, I think, initiated this item a couple weeks back. And I've got to say, I don't think I've ever more strongly disagreed with the staff report. I think that the characterization of the board's power, the limitations of the board's quasi-judicial and quasi-legislative capacity were extremely limited in a way that I just fundamentally disagree with. I think that each of us bring important and unique perspectives to the board, and that we should take we should be thoughtful and progressive about the ways in which we try to include all members of the board in participating. And so, I think that especially this election season, we're hearing a lot of talk about, what is the appropriate delegation of power of elected officials vis-a-vis staff members. And I think, there are a lot of pressures and a lot of desire among our community to empower our electeds more. And while we greatly appreciate, everything that staff does here, I don't think that we should be, curtailing the ability of our rent control board electeds so severely, particularly when there's no real, at least from what the staff report says, no real consensus as to what a best practice is. And I would note that many parliamentary rulemaking guides, including Robert's rules, have become increasingly progressive about accommodating teleconferences, accommodating electronic participation. And I think given the fact that this is something that the body has never done, it's premature at best, prejudicial at worst to say that teleconferencing doesn't work when we've never even tried it. So, I think as an elected official, I take my responsibilities incredibly seriously, and I appreciate the understanding of members of the public who acknowledge this is a volunteer position. We all have full-time jobs. We are doing our absolute best to give, everything we can in many ways to serve this board. And, if this were a full-time job, perhaps the calculus would be slightly different, but we all have to make a living. And I think that, there are reasons why the Brown Act provides for participation via teleconference. There are reasons why the Brown Act does not curtail it. And notwithstanding the preamble of the Brown Act, there's nothing in the Brown Act that suggests that participation by teleconference undermines democracy or is anti-democratic. And honestly, I would say that remote participation actually advances democracy. And I don't think that, before we actually experience participation, or at least an attempted participation via teleconference, we can really say whether it substantially impedes a commissioner's ability to participate or interact with members of the public. And I think the understanding among the board members would likely be that this is the exception, that there is an expectation of decorum, there's an expectation of restraint in seeking the remedy, but that we should not be making arbitrary restrictions when we haven't even seen a propensity for abuse. So my recommendation would be to allow it to the extent permitted under the Brown Act, and when requested by commissioners and fully in compliance with the Brown Act and all of its notice requirements, which are stringent and fair and just and what we are otherwise bound by. And I do it because I care about honoring the responsibility that I have to my constituents. And in my view, honoring that responsibility means trying to avail myself of every opportunity to participate in a meeting, primarily in person, but if not possible, by teleconference. So that's my position, and I'm looking forward to hearing the positions of my fellow commissioners.
So thank you. So I am going to jump in here because I had an absence earlier this summer that was referred to during the discussion that I watched on TV because I couldn't be here on the internet. So I think part of the job we signed up for when we ran for office is to face the public and stakeholders of all kinds, as tough as it may be. But I do also agree that I think the technology is there. I would be inclined to agree with a couple of the staff's options to cut it to the quick. That no more than one commissioner may appear at any open or closed session by teleconference in the same meeting. I think it would be too disruptive to have competing technologies overlapping and speakerphones and data streams. It could be too much. So I think that staff's suggestion, subdivision D, alternative 5 in Exhibit A, is a good one to include. Also, just prior to that on page 2, subdivision D, alternative 4, within the United States, I'm flexible on that one, but I do think it's hard to have ADA compliance and a reliable internet connection if you're not in the good old US of A. So I think that's a possible reasonable accommodation, a limitation that I would be okay with. Okay. I also would favor limiting participating absences to extreme circumstances. But we are adults and we are elected officials, which means 12, 13, 14,000 people thought it was a good idea that we sit in this chair. So I think we can be trusted without doing a vote at a prior meeting that far in advance to reasonably accommodate our fellow commissioners and work with staff to develop a plan should something arise. But I think you can trust us not to abuse something where, let's say there's a light agenda, which I don't remember the last time there was, but occasionally there's like 2 owner occupancy exemptions and that's it. And in that case, I don't think we should avail ourselves of, well, I'm just going to go on vacation and chime in from afar on a very light agenda. I would really like to see fellow commissioners limit it to more extreme circumstances on important agenda items. And I think we can all be trusted to follow that if we try this. And I agree with Commissioner Phyllis. If we try it, and it's really horrible, then we should re-examine it, and we should ask staff. I for one would direct staff to and would try to gather consensus to direct staff to outline a suggested set of clear parameters, like the report did suggest we do, so that it's not left up to question and it's not left up to chance each time. For my part, I would include recommendation D, no more than one commissioner, that it be in the United States, and that it be limited to extreme circumstances under our own auspices. That's all I have to say. Commissioner Trosas.
Okay. Again, I think there is precedent for doing this. I think that the Brown Act is clear that this is permissible activity, and any other such argument is refuted by myself, and at the very least, because again, like I've mentioned, and I probably sound like I'm repeating myself, this is certainly done at the county. I, without speaking to anyone before this on this item, actually agree with Commissioner Foster. I was going to say I think we need to do start with subdivision D, alternative 5, that no more than one commissioner may appear by teleconference, and I actually would be in favor of subject to adding subdivision D, alternative 1, subject to limitations and noticing requirements imposed by Government Code 54953. The reason for that is that I think, again, this needs to be evaluated on a case-by-case basis. I think we're all adults. I think we're reasonable. I would never, ever appear by teleconference unless it was absolutely urgent, imperative. I think all of us feel that way, but I do think that because the nature of this position and the nature of the fact that we all have jobs, sometimes there are extenuating circumstances beyond our control. Of course, it would all be noticed and done in advance in compliance with the Brown Act, but I think that we can make sure that the space that we choose is ADA compliant and the technology is there.
Thank you. Commissioner Duran?
So having heard my fellow commissioners, I think I'm gonna be on the other side of the fence on this. So I'll make my points, and this is what they are. I think it's important that transparency remain at the forefront, and I'm not suggesting by any way that my fellow commissioners here tonight are suggesting anything otherwise. But my concern, number one, is the slippery slope that this potentially creates for later boards, and what may be important to these folks that I've worked with for the past 2 to 4 years. I know their concerns are primarily with their duties and obligations here on this board, and I'm not concerned with them whatsoever. It's what comes next that I worry about. I also think that there's a lot to be said about it's not only about the commissioners being present for the audience or for participation. It's also for the public to be able to confront us, and to do that effectively, I think we need to be present. This is, I think, similar to what I said at the last discussion we had about this, and I don't think I know that my position hasn't changed. So for those reasons, I guess I feel more strongly that I don't think that commissioners should be able to appear at an open or a closed session by teleconference. However, having heard my fellow commissioners, I know that that's going to be in the minority vote. So as a compromise, I would like to suggest and offer that in addition, should teleconferencing be allowed, that it only be done in the extraordinary circumstances that includes serious illness, disability, as stated in subdivision D, alternate number 9. That's something that I could live with, and that it only appeared or only be allowed for one member at a time for the reasons discussed earlier. I think that makes sense. It could get confusing. And I'd also like to highlight, I think, a good example by Chair Foster in regard to the slippery slope. While I have every confidence that none of us would decide to take that extra, long weekend on a night where we know that there's a very small agenda, and just do it out in the field somewhere. I know our obligation would be to show up here and do this, if at all possible. I don't know about future boards, so those are my concerns.
Thank you, Commissioner Drone.
Okay, thank
you. Sorry, I thought you were.
No, that's fine. That's fine.
Okay.
Thank you.
All right. So I'll say, for my part, to reiterate my 2 points on this, I hope it almost never happens. I hope that there's almost never an occasion where we're not all here to look our constituents and stakeholders in the eye. I hope it almost never happens. However, if it's my wedding planned a year in advance and there's an important vote and I can reasonably participate, I don't want it to be limited to only extreme illness. However, if my mother's going through cancer treatments in Missouri and I want to be there to hold her hand, but the meeting's the day before, and I can reasonably schedule it and accommodate it, I think that, again, we are reasonable enough adults to keep it to the absolute bare minimum. And I share your concern about somebody might abuse it, but 3 out of 5 of this board probably would not abuse it, and we could rein each other in by changing the rule back at any time. So do you need us to vote openly, or is this a consensus issue?
Well, we're asking you to indicate to us what provisions you would like to include so that we can bring it back at the next meeting as a regulation to be adopted. So to reach a consensus about which alternatives you'd like to include. I would like to second that this has never been a problem. Thankfully, we've had great participation by board members in my whole history here with the agency, and we've never had an issue where we didn't hold a meeting because of lack of a quorum, as far as I know. So as far as I know, this would not be a problem. I think that we can give it a try, and hopefully it will work if there is an extreme circumstance where somebody needs to participate by teleconference. And technology has improved, so we should give that a try. But I think what we've done in the past, the board members have been very responsible in being at board meetings, and it hasn't been a problem. So I just wanted to say that. So if you can build your consensus and indicate what you want the regulation specifically to say, we will bring that back at the next meeting.
Commissioner Phyllis?
So I just want to say, with regard to the slippery slope concerns, well, I think that's kind of something that's easy to imagine in the hypothetical. I like to work in the world of hard numbers, and there's not a single example in the staff report of it being a slippery slope where boards have deteriorated because people have so profoundly abused a telephonic meeting rule. There's not a single example where the votes have been compromised or challenged because people have participated telephonically. I mean, at worst, I think I've seen, and I have seen this, right? This does happen with technology, where sometimes the technology is a little bit difficult the first time that you do that. That is one thing I have seen, but I don't consider that a slippery slope, and I don't think that I'm not persuaded that the risk of precluding my fellow commissioners who I care to hear, I would much rather err on the side of inclusion and participation than compel an absence where they can't participate at all. I think that, that it's worth a try. So with that said, I'm open to limiting 1 to 1 absence
I'm sorry, what?
one telephonic participation per meeting. So whichever commissioner says, "Oh, I need to be participating telephonically first," should get the priority.
First come, first serve.
Yeah, first come, first serve. So let's say I'm like, "Oh gosh, I need to."
We
do
understand.
it. Right.
First come,
Okay.
first serve.
Understand. Sorry, but I do not support limiting the number of times someone can participate telephonically. I do not support limiting the situations in which one can participate electronically. I think we're all adults, and I don't also like the idea of using even nebulous terms like what is an extreme circumstance. I mean, that is unless it's a defined term, it's kind of meaningless. I think, the expectation is that it will be used sparingly, but ultimately in the discretion of the board members within the limits of the Brown Act. And if the technology fails, then the commissioner,
can't participate.
And that's it. So that's where I'm at. I appreciate my fellow commissioners hearing me out on this.
Steve Duran, you're up.
Well, I think that the comments that were just made, it's hearsay. It's unsupported by any evidence either way. So it's opinion. And so I would caution fellow commissioners that opinions are fine, but just as there may be no, it strikes me as just being an opinion in opposition to the points that I had raised earlier, as opposed to evidence. I don't know if we're at the point where we're still making suggestions as to what
Let's
should
start
be
the
approved.
list.
Okay, why don't we do that? So while I still have the mic, I will say that I would be able to compromise and agree with allowing teleconference with alternative number 9, as well as limiting it to one person per meeting. I don't know which option or what alternative that. Okay, alternative number 5.
I think we all agree on that one. We can
Okay.
move forward. How do you feel about the United States?
No, just do one. It's easier. Yeah, one is easy. Why do we need to limit?
Oh, it's fine.
I think we all are adults here.
Yeah,
That
no.
it meets Brown Act requirements.
Right.
Government code.
Sure, I would agree with that.
Okay.
And I also agree we're all adults.
Sorry, I'm just trying to keep a score sheet here.
Okay, so where am I at? 1, 5, and 9. Those would be what I would be willing to compromise on. Thank you.
Okay. I'm next. I forgot to give an example that I think is relevant. 7 or 8 months ago, I watched a 5-hour Berkeley Rent Board meeting, because that's what I do with my spare time, is watch 5-hour Berkeley Rent Board meetings. And there was a commissioner who was participating remotely. And it was painful only because, and that's what I'm going to ask staff to also include in this list, he was using a cell phone while driving a long distance.
That's a Brown Act violation.
And well, he was using a cell phone. At some point, I swear I heard traffic noise, but But also, the clerk, the secretary of the board, was using their personal iPhone and holding it in front of a mic the entire night.
No, we're not doing
And
that.
at one point, they paused the meeting. I'm not kidding. At one point, they paused the meeting to say, "My phone's dying. Can we get another phone?" So if we're going to do this, I mean, Lonnie, I know your arm's strong, but, it might get tiring after a while. If we're going to try this at some, I hope, almost never future date, I want staff to include a proposal for what equipment you would be receiving this call on, and what type of phonics or audiophonics that the audience at home, both at home on City TV and here in the room, what would they be hearing and how? I'd like to hear some sort of presentation of what other districts have actually used that does work well.
FaceTime? Just FaceTime?
What do we have the capability to use, and what have you seen best practices used in other jurisdictions where it has worked well? I'd like to specifically hear what that equipment is, and I'd also like to put a requirement on any remotely participating commissioners that we agree to not only obviously be in the noticed, government compliant spaces, but that the technology we use be on a dedicated, secure Wi-Fi line so that there's no risk of interruption.
Can I?
Yes, you may. Commissioner Trost.
I'm at 1 and 5, not 9.
Also 1 and 5.
I'm ready to take a vote. I also would say, as a best practice, we should try to do teleconferencing wherever possible. Our Board of Supervisors has a remote location in the Antelope Valley that they accept teleconferencing in to make public comment at our board meetings. I think that being able to see someone's face is always good, and I think that we should try to adopt teleconferencing as a best practice.
Do you mean video?
Teleconferencing
Video?
or video?
Sorry, video conferencing. I'm too late.
Yeah.
Video conferencing.
So encouraging video conferencing is fine, but I think staff's going to have to wrangle with one or another form of technology and get it mastered. And if we ask them to do two up front, that might be more challenging. So where I'm at is 1, 5, and a requirement that a dedicated piece of equipment, that staff have a specific piece of equipment.
Talk to ISD and City TV.
Oh, ISD and City TV, we love you. Help us
Right,
out.
to see what the capability is with the equipment that we currently have in this room. I can see some possibilities. I mean, we've done a teleconference for hearings here
If City TV can
on
play
a basic level,
PowerPoints,
but
they can do this.
yeah. So we'll hopefully by the next meeting I can get an answer for that.
All right, so do I hear consensus for 1, 5, and answering the question of what the technology process would be?
For 3 people, yes.
From 3? All right, thank you. The matter is closed. And moving on with all due haste to item 12C, board consideration signing of Commissioner Phyllis's proposed letter to City Council regarding funding options for owners required to complete seismic retrofitting of controlled rental properties and encouraging investigation of price gouging complaints of owners. Take it away, Commissioner Phyllis.
Okay, so this is a letter
And Commissioner Trost.
that we wrote in response to communications that we had received from members of the housing provider community, and in light of the some time has passed between the initial seismic retrofitting rollout and now, and what we had heard from the housing provider community, among other things, was one, that the cost of seismic retrofittings were higher than what was initially projected, some in like the $80,000 to $100,000 range. And 2, that there were examples of like price gouging in Santa Monica because unclear what the cause was, but there was some concern that it was because the permitting process is onerous. There was some concern because there just aren't enough contractors in Santa Monica to actually provide these services who are licensed. So we undertook to write a letter to reiterate Resolution 17005, which we passed in December 2015 to urge City Council, December 2017, to urge City Council to consider a financing program for low and no interest loans in light of outside of the PACE program, which I understand is much more restrictive in terms of its availability, to help housing providers come up with the initial costs to cover earthquake retrofitting. So I've put together a letter, and I have some substantive, like some minor nits in the letter, namely the number for the smaller sized units or the smaller sized buildings is not 4577. It's actually it is 2,988, so just about 3,000 units. So a little less than 30%, not 40%. That's on page 2. And then also noting on page 2 in the second paragraph that other jurisdictions, including Los Angeles and San Francisco, exempt smaller size buildings from earthquake retrofitting compliance, which is something that Santa Monica does not do, but that some of these smaller size buildings actually have more cash flow issues to finance earthquake retrofitting, just because of the way that loans are structured. So there are different challenges depending on different sizes of the buildings. So while this letter urges City Council to take up a feasibility study of financing options and financing programs, there may be other issues for us to consider down the line, which is communicating with City Council about the scope of units affected if it remains increasingly difficult, especially for these smaller sized buildings, to obtain financing to do earthquake retrofitting. And those are about 1/3 of all of the units that appear to need to be 1/3, maybe a little less than 1/3, that need to be retrofitted. So this is the letter. The last portion of the letter concerns the fact that the City of Los Angeles, also at the urging of their Budget and Finance Committee, undertook a similar feasibility study of a financing program in March 2018. So this would bring Santa Monica in line with the City of LA, which obviously recognized a need for financing options outside the PACE program to help people comply. And they have even more assistance with financing because they allow for pass-throughs, which is something that the City of Santa Monica, because of the language of our charter, does not. So this letter tries to address all of those needs and express to City Council the urgency for taking up a feasibility study, and I would urge my fellow commissioners to support it.
Commissioner Trosses?
Yep, I just want to thank Commissioner Phyllis for taking the lead in putting together this letter. I think it accurately captures how I feel about this issue. I have been concerned from day one, actually pre-day one, before we even discussed this, about the cost and the high cost. I think that for these small landlords, and we saw in our previous item that there are a preponderance of very small buildings in Santa Monica. It's very hard for cash flow purposes to qualify for low interest rate loans, thus making it even more expensive. Additionally, we have the compounded problem of potential price gouging as the number of people needing earthquake retrofitting continues to go up as people are evaluating whether or not their building is seismically safe. Among multiple jurisdictions, not just Santa Monica. I actually think I'm really disappointed in City Council for not having expeditiously taken this up. We've asked multiple times. I feel like it's falling on deaf ears. I think this is a health and safety issue. This is a consumer protection issue. I don't know how many times I can say it. I'm with all of our landlord community, our housing provider community, in making incentives to get this done as quickly as possible. But I hope people understand that this is outside of our jurisdiction. So if you are concerned about this, we need everyone to lobby City Council to make some changes, and we would like your support in urging City Council to at least explore other financing options. With that being said, my only kind of immaterial change to the letter, but just in terms of structure, I think it would be good to remind City Council at the beginning of the letter. I mean, of course, I always write things maybe too strongly worded, but I think we're being too nice at the beginning. I think we need to say that this is following like a resolution that we sent you on X date, urging you to explore financing options, and yet again we're coming back to you implore you expeditiously. I don't know, something a little bit more urgent, and probably just to remind them that this has gone unanswered now for several months. So. But other than that, I think it's great, and this is succinct and to the point, and thank you for putting this together, and I support moving forward with it.
Yeah, thank you, Commissioner Phyllis, for writing this, taking the laboring oar on this. I think it's a very well-written letter, and I'm fine with the way it is and submitting this to the council. I'm also okay with Commissioner Trosses' comments and wording it more strongly if you think that would be appropriate. Yeah, so that's all I wanted to say. I appreciate your effort on doing that, and I think that this is a very good letter as written. Thank you.
So I'm generally in favor of exactly what this is trying to promote, and I absolutely agree that some owners are going to struggle with this process. We have heard from some owners that are struggling with this process. But I would like to think that the safety of their tenants and the preservation of their investment and the fact that it's a requirement of the law, all three would weigh heavily in helping them get themselves educated. I hope that their various trade associations they belong to are helping them in this manner, and that they're availing themselves of I've attended some of the city seminars they've offered. There's a lot of resources available to help these folks, and I hope everyone finds what they need. That being said, I'm okay with reiterating to council that this has been requested by this board, but I don't necessarily agree with using stronger language, because I think just in the spirit of collegiality and mutual respect between bodies, I think simply sending the letter twice will get the point across that knock knock, we're here again, rather than wording it more strongly. I think that could be misconstrued by some in the public or some on the council as being disrespectful and overreaching our authority. So I'm okay with signing on to a letter as is, though I think that it being a requirement of law and in the interests of human decency and public safety and preservation of our housing stock and people's investment, that it will happen. And I do think people deserve options for financing if they can prove and demonstrate a need. Commissioner Phyllis.
So I'll say that I will add a gentle but clear reminder that this upfront is a follow-up on the resolution that we sent to them in December.
Well, for one, I'd need to see it, so I can't agree to sign on to something before I've seen it. Do you want to table it till the next meeting?
No, I'm just suggesting to move per paragraph, or not paragraph, but
So the second to last paragraph after the first paragraph?
I'm sorry, which one?
In December 2017.
Yep.
Sorry, I don't know that this is, are we supposed to edit this on the?
Well, we either have to, because I'm not going to sign something I haven't seen, so we either edit it now, or we can table it till November.
You need to move it?
I feel like you can send. Are you really not okay with us just taking this sentence from the top?
Well, that's not
of
what
the
you
paragraph?
suggested first. You said using strong wording.
Okay,
you didn't say use this sentence. So if you substitute a sentence, that's easier to
I have
understand.
a sentence that I can add in right here. Okay, so I write on behalf of and with the support of Santa Monica Rent Control Board to respectfully request that City Council undertake a feasibility study and survey of potential funding sources regarding low-cost public financing for seismic retrofitting. This request comes after 11 months. It comes 11 months after our initial resolution 17-005, which conveyed a similar request in December 2017.
That is respectful.
That's fine.
Okay, and then I just want to be clear, because I want to make sure the numbers are correct and accurate, that I'm changing, it's not 40%, it's a little less than 30, so I'm going to make sure that's clear. And then I also want to note that in Los Angeles, it's buildings of 3 units or smaller that are exempt, and in San Francisco, it's units that are 4 units or smaller are exempt.
So what are your edits there?
So which have been exempted by other jurisdictions like Los Angeles, which specifically provides that buildings of 3 units or smaller are exempt from compliance, and San Francisco, which provides that buildings of 4 units or smaller are exempt from, like Los Angeles, and then, okay.
I would also just say, in that next paragraph, since we're striking that whole sentence in December 2017, I would just say since passing our initial resolution, we have been informed by stakeholders in the housing. Yeah.
Yeah. So instead of the since passing our resolution.
Yeah.
Okay. Okay.
Fabulous.
So,
Tracy, you have those edits?
No, but Lonnie's been doing them as you've been speaking.
Okay.
So when we move on to the next item, I can talk about the budget, then we can do your board discussion item, and then Lonnie can print out what you've just edited. Would that work, Lonnie?
Okay.
Okay, and then we can print a final version for you to sign on behalf of the board, if that's the intention.
Okay.
Okay.
All right. Moving along to the final budget report for fiscal year 2017-2018. May we have a staff report?
Yes, this is just an informational item tonight. It doesn't require any board action. The written report is quite detailed, so I'm just going to highlight a couple of points. Last year, the board adopted a budget of $5,181,000. There were no additional appropriations or modifications to the budget during the year. With projected revenue of $5,270,000, the board adopted a budget with a small surplus of $89,000. Because a budget is an educated prediction of projected revenue and expenses, there are often variations in both revenue collected and expenditures occur, which is true this past year as well. Overall, for the past fiscal year, the board collected approximately $78,000 more in revenue than was originally projected, and that was in large part due to collection of past year's registration fees that had been unpaid. The board staff attorney, Mr. Mordezai, and Ms. Evans and Ms. Diaz of the public information staff have worked very hard on this effort, and it has been successful. Almost $60,000 additional dollars were collected this year. We also reduced our expenditures by almost $407,000, resulting in a net increase to the agency's reserves of approximately $615,000 at the end of the last fiscal year, and that was after making the board's initial payment towards the PERS loan of about $49,000. While we did have significant savings, as we discussed in quite detail when the board adopted the current year's budget, a large portion of those savings will be applied to the board's implementation of the new property and rent tracking system. So as I said, the written report provides more detail, and I'm happy to answer any questions. This is just an informational item for you.
Well, I, for one, am impressed, as I am every year, at how closely your agency is able to stick to its budget and live within its means. It's truly impressive, and I wish every government agency ran as efficiently as yours does.
Well, you see that part of those salary savings were the result of people being on leave, and that does put some extra pressure on the board, which is one reason why we had over expenditures in the area of as needed hearing officers. But we need to be able to hear the cases that are filed, and so we have had to use the as needed hearing officers more than we had projected this previous year. And given the fact that we will have retirements coming up, as we've talked about, we foresee that we'll probably be doing that in the coming year as well. So,
but you've planned for it.
Yes, we have planned for it. But I also, of course, want to thank Ms. Noseworthy for her hard work on this. She does a great job, and Mr. Gwynn has been helping her as well. So thank you to both of them.
Yeah, staff, both in this report, and I meant to say it in one of the prior items we had tonight, your mastery of data, Lima, Dan, Amy, council, staff, Infocos, all of you, it's incredible the amount of data you're able to parse in a short amount of time. You turn things around for us at our request, sometimes with 2 weeks notice, 3 weeks notice. You produce substantive, thorough reports of data that represents something I also wish every city department and every government department could emulate. So I just wanted to say that. Do you need us to take any action? It's just simply a report. Thank you. We're on to, oh yes, sorry, Commissioner Duran, I didn't see you in there.
Thank you. I also wanted to say, in spite of, despite of, whatever that word is, with the work, the adjustments you had to make, you were still able to get it within budget, and I just wanted to commend you and your staff for doing it year after year, and making us run efficiently. So thank you for that.
Item 14A, request of Commissioner Phyllis for a follow-up discussion regarding the status of the estimated potential financial impact of Measure SMS on tenants and property owners, and a request for Rent Control Board staff to explain communications with the proponents of Measure SMS. Commissioner Phyllis, would you like to address the item?
Yeah, so this is just a quick follow-up item, again, in the spirit of transparency, and because members of the public had asked if staff could share what communications they've had with any regarding how to calculate potential impacts on tenants and property owners of future pass-throughs related to Measure SMS.
Sure. So since your last meeting, I've had conversations with both representatives of the committee sponsoring Measure SMS and members of the school board. They put me in touch with the underwriter for the district's bonds, a company called Raymond James, who did the calculations of the estimated impact on property owners and tenants of controlled units. The bond underwriter explained that school districts across the state obtain information used to conduct this type of analysis from a company called CalMuni, which has been providing California municipal bond information and research since 1932. So although we had offered to provide any information that could be helpful to the district or the proponents of the measure, they were able to calculate the estimated impact on properties with the information and resources that they had. So they did not need to, for us to provide any information. The FAQs on the Measure SMS website have recently been updated to provide some additional information about the calculation of the estimated per unit impact. But as they indicated and as we've talked about, there are a number of factors that go into what that actual impact will be. And like we often do, they had to look at a median unit to come up with their estimated cost, because as we've talked about, the bonds vary significantly depending on the assessed value of the property. So we've talked with them. They did their analysis without any need for data from us, but we were available if they wanted it.
I have a question for staff. Isn't it also true, in my research on this topic, there's a state law that governs what like a ceiling of a portion of a bond that can be implemented or sold at any one time, such that the entirety of the bond would not be spent and assessed all at once. Isn't that correct? It would be sort of unpredictable what interest rate they would sell it at and which portion of it they would use for which capital project. So it's kind of a tough question to answer. Isn't that true?
Well, that's true. I don't know about the state law. I'm certainly not an expert in this area, but I do know that the district's practice has not been to issue all the bonds at once. They come up with a plan of how they're going to use them, and then they issue whatever portion of the authorization they've received. And so I've never seen them issue all the bonds at one time. So it's usually done in a number of steps over a number of years.
So when I saw the statistical figure of $3 and whatever it was, per unit, I think they made a good faith effort to try to parse the data, just like Measure V did and some other people did for tenants. But I think the real answer is we don't really know, but we do know one thing: there's a cap. So
that's exactly right.
There's a cap that was philosophically designed on this dais, to, at least for our part, to reasonably accommodate public support and tenant support of things like voter indebtedness taxes, while also preserving some sort of stability for accounting for the speculative real estate market. So I'm comfortable. I'm actually comfortable with the fact that the school board measure supporters can't give us an ironclad exact answer. It's unfortunate, but it doesn't exist, and I don't think it's ever existed for any school bond that's ever been passed anywhere in the United States. So we've got to go. Tenants for themselves who are registered to vote here have to go with their gut and take the information that's been given. As far as I'm concerned, I'm glad that our agency participated and that Commissioner Phyllis brought this up.
Right, and I'm glad you raised the point that you worked very hard over the past several months to come up with the cap of $35. You did that based upon a lot of analysis of data, as you mentioned. And that is where the board has a role in this, is if at some point in the future, as you discussed when you adopted the $35 cap, if you feel there's a need to make an adjustment in that, that would be, the board would have the authority to do that. Thank you.
After we see how much the bond is and what the impacts
and it
are.
might not be this one because when you adopted the $35 limit, that was not going to impact a huge percentage of the property owners. So presumably there's leeway still within that cap for most property owners.
I would agree with that. All right. Do we want to go back and revisit the letter? Commissioner Trosas.
Yeah, I want to make a couple of additional edits, Mr. Gwynn. First of all, can we capitalize resolution in the first paragraph when we wrote resolution 17-005? Further, in the second to last paragraph, we have to delete the sentence in December 2017. And I would just say, since passing either the resolution or our resolution in December 2017, we have been informed by stakeholders in the housing provider community. I do not believe that is redundant because we referenced the December 2017 resolution at the very beginning. So I just think saying...
Yeah, and just capitalize resolution.
Capitalize throughout. I don't know. Are you going to make sure that this comports with any sort of rules regarding like Honorable Ted Winter? Like, are we going to just grammatically check all of this stuff, or is
so?
I copied that.
I checked with staff earlier
right.
today regarding that. I said, is this a resolution? Is this a letter? In 3 years, I have not done a letter as opposed to a resolution. So staff actually referred me to the letter Mayor Ted Winter recently wrote to us and said yes.
Oh, okay. So this is the correct format. That's all I was asking.
It is It is common practice it's accepted practice to do a letter like this. Any and all rent board members may or may not sign on to it.
I would also request that we copy all members of the rent control board personally if we are signing on to it at the bottom.
Mm-hmm.
I don't know, just for Todd's, Commissioner Flora's own edification, we can probably just copy him even though he isn't here.
Because we know he's watching at home.
Yeah, I'm willing to sign, to do a forced signature letter if all four of us want to sign it right now.
I'm fine with that.
Okay.
And I think Nicole Phillips should be the first signature because she
of course.
authored it.
Yeah.
The rest. The staff did not author it, and the chair did not author it. So I just feel her name
definitely should be on behalf of Nicole wrote it, but I don't know if there's any way to put our signatures below.
Is that something we can do after adjournment?
Yeah. Signing?
Doing the business. I think it's doing the business. I think we should do it
on the record
session. Yeah.
All right. Well, we have nothing left to do. So when Mr. Gwynn lets us know that he's ready, we will.
That starts with in December 2017 and ends with. No, just say since passing the resolution in December 2017, we have been informed by stakeholders.
And resolution should be capitalized in that paragraph.
In all paragraphs.
In all paragraphs, which I think it is, except for that one.
And the first paragraph too.
Yeah.
And then if you want to CC us at the bottom.
Yes, please.
Sure. And then I can either sign it next to my CC or I don't know what the signing.
I'll sign it in the block,
okay.
So I'll just make it small. We can all sign. Small.
Yeah, if we all want to sign, I'm amenable to that as well.
So you just want me to put each of your names and titles underneath Nicole's, and then you can just all sign it.
Sure.
I mean,
no. Or we can just put Nicole's and then all sign. I don't know how.
I can do Nicole for RCB.
Okay.
Like for Rent Control Board.
Sure.
But you want the CC to have your individual names instead of Santa Monica Rent Control Board.
And Santa Monica Rent Control Board.
That is us. That does encompass all of us.
But I mean, it should.
But you want your names
and our names. Yeah.
Okay.
Is that okay?
Sure.
I don't know. I mean, I'm just hoping that this is going to be a shining example for other people to look at, and it's going to be in the public record. So we need to make sure we get it right.
Yeah.
It's going to be in the public record.
I'm sure council's going to print this out and frame it.
I mean,
in their individual
they better
homes.
take us seriously.
Okay.
Our fans are here waiting for us to adjourn.
It's all right, Lonnie. No pressure. No pressure.
Nope. People are leaving. What if I do a read-in item after they leave? Wait, what? Okay, after reviewing the letter, this meets my satisfaction. I'm happy. Wait, hold on. Now we've eliminated the Santa Monica Rent Control Board as a CC. Is that a problem? Oh, okay. All right. Is this okay?
I'm good with this.
All right. I'm fine to sign this. Or you're signing it for RCB. Okay. I move to approve the letter and authorize staff to send it to Mayor Winter on behalf of the Rent Control Board, with our sincere thanks to Nicole Phyllis for authoring the letter. Do we want to second that?
Do we need a vote? It's just happening. All right, all those in favor say aye.
Aye.
Aye. All right. All right, with that magic moment,
Move to adjourn.
I'll take that as a first and a second. We are adjourned. Thank you, Rebecca, for filling in.